It's a great honour to be joined here by Mr Justice Adrian Hardiman of the Supreme Court of Ireland to talk to us about the trial of Robert Emmet. You're very welcome, Judge Hardiman.
Thank you very much.
Can we begin by asking, I suppose, the most obvious question? Did Robert Emmet have a fair trial?
I think there's no doubt that he did not have a fair trial. He said himself the verdict was already given in the castle before the jury was impanelled. And there's no doubt it was a show trial, just as surely as Stalin show trials were scripted.
And I suppose he kind of walked into their trap in a little bit because once he was captured, they realised this is the person we can hang the whole thing on.
Yes. It's the difference between the Emmet trial and the Stalin trials was that Emmet actively cooperated in his own conviction. When he was captured, he had letters on him. There were letters from his girlfriend, Sarah Curran, who was quite a prominent person. She was the daughter of the prominent nationalist lawyer and politician, John Philpott Curran. She had begged Emmet to destroy the letters, but he didn't do so. He also kept locks of her hair. Some days after he was captured, he was interrogated in the castle by a group of very important people, the Lord Chancellor, the Attorney General, the Chief Secretary and such like. And he refused to say anything. He took the fifth, as it were, until the letters were produced. And when the letters were produced, he simply broke. He said, "What can I do to stop these letters being produced?" The interrogators didn't quite know what was going on because they didn't believe that they were love letters, although they looked like love letters. They believed they were a military code in which the language, as they put it, the language of a love intrigue had been assumed. But it was clear that Emmet was very, very worried about the letters being brought forward, and he eventually said that he would do anything to prevent the letters being brought forward. He said his personal safety wouldn't counter them at all if he could do that. So the government knew that they had an ace, and they promptly sent him back to prison, and he promptly obliged them by bribing a turnkey, a prison warder, to deliver a letter to Sarah Curran at her real address. So very shortly afterwards, they knew exactly what the position was.
And copies of those love letters were even sent to King George III.
Yes, they made copies, and one of them was given to the king. And the king remarked, "Mamselle," meaning the young lady, "Mamselle is a real Mary Wollstonecraft," the early feminist. But Mamselle, in fact, or the letters from Mamselle, hanged Emmet.
Because, and even at the trial, they didn't reveal anything about Sarah Curran because of that deal.
They knew the deal was that he would make no attempt to defend himself, so long as they did not bring her forward or implicate her. Now, they had told him, that the person who wrote the letters was also guilty of high treason and might be hanged. So they had worked on him in that way. And but once they entered into the deal, they kept it, even to the extent of getting the lawyer to say in court that they were letters from a brother conspirator.
There wasn't really that much evidence against Emmet. Is it possible that without that blackmail, he could have actually escaped?
Well, about 3 weeks before the trial, the Chief Secretary, that's the person in the position of the Prime Minister in a more normal government, wrote to the government in Britain, preparing them for the prospect that Emmet might be acquitted. He said, "Nearly all the evidence we have is documentary, and we can't prove that it's in Emmet's handwriting." And he said something very interesting. He said, "Our case is so bad that we gave serious consideration to bringing forward a most reliable source of information." But he said, "We all agreed that it would be 1,000 times better that Emmet would escape than that that source of information would be forever dried up." So he thought, obviously, that the case was so bad that he might need to bring forward his principal informant. But of course, if you bring him forward in the public court, you could never use him again because he will never be told anything again. There seems to be no doubt from the context that the informant they were talking about was Leonard McNally, who was the leading radical lawyer in the country at the time. But though he looked like and sounded like a radical lawyer, he was a government informant for more than 20 years.
And of course, he was defending Emmet because John Philpot Curran refused to take the case.
Yes. The government didn't force Emmet to instruct Leonard McNally, but they did force John Philpot Curran to withdraw. And once he withdrew, it was very likely that McNally would be briefed because of his standing as the leading radical lawyer.
The whole affair doesn't reflect very well on John Philpot Curran. He seems to have put his own ambition ahead of everything else.
It had a devastating effect on Curran. He was the leading Whig politician, that's, so to speak, a conservative radical. He was also a prominent political lawyer. He passed completely into the power of the government. They were able to, because of course he was afraid that his daughter would be charged with some offence, possibly even high treason. About 6 months after Emmet's trial, he was the defence counsel in another political case where some information embarrassing to the government was going to come out. And in the archives, there is a letter from the Chief Secretary saying, "It is well that Mr. Curran is completely in our power."
As a lawyer and then as a judge, you have heard lots of great speeches in court. I'm sure you've delivered many of them as well. How does Emmet's oration in the dock compare?
Well, of course, one hasn't heard Emmet's oration, but one has read it in the various versions. It was common case in all shades of opinion that it was a magnificent speech. The speech itself passed into the canon of great speeches, with the result that it featured in an American compendium of great speeches which Abraham Lincoln studied when he was a schoolboy. It was acknowledged by friend and foe alike to have been a fine speech. There is dispute about exactly what was said because, though there was a shorthand writer in court, it was the end of a very long day, and there are disputes as to whether the whole of it was in fact delivered. Emmet himself said that he had more to say, but the judge was cutting him off. Particularly the peroration at the end, "When my country takes her place amongst the nations of the earth, then and not till then shall my epitaph be written." That made a huge effect in Ireland, which was very long lasting. Over 100 years later, on Bloomsday, the day on which Joyce's great novel Ulysses is set, that speech resounds in the mind of various of the characters.
And famously with Leopold Bloom.
Yes, famously with Leopold Bloom, he keeps time, so to speak, with the speech by, how can one put this delicately, by crepitations.
By breaking wind.
Precisely.
What about the judge who you mentioned there, Lord Norbury, who kept interrupting Emmet?
Yes.
Did he behave correctly there?
He appeared to behave very correctly throughout the hearing, but there's no doubt that he was in on the plan to force Emmet to make no defence. For example, the letters were produced, including the letters from Sarah Curran, and they were placed on the bench in front of Norbury. And he said something which sounds very fair, but was in fact a threat. He said, "The prosecution are going to open one of these letters." He said, "but if the prisoner wants the rest of them read, then of course he may." Now that sounded and must have struck the people listening as an extremely fair and impartial thing. But to those who knew what had gone on between Emmet and the state lawyers, in Dublin Castle, he was threatening him that if he didn't behave, his girlfriend's letters would be read out.
Given that Leonard McNally was reporting on everything to Dublin Castle, selling out the defence, in other words, would that in any way have invalidated the verdict?
Well, according to our standards now, it certainly would, if it were shown that the state, the Crown, the prosecution had bribed the defence lawyer and received regular reports from him before, during and after the trial. Then of course it would invalidate the proceedings. But standards, it's impossible to apply the standards that have been evolved over the centuries since then, retrospectively, just as you couldn't criticise a doctor of the day for failing to administer penicillin.
And what about the I suppose the acts of treason that were used, the actual the laws that were used against? It went back to very ancient statutes, but that seems very complex and kind of confusing.
Well, the effect, the constitution of the offence of treason dates back to a statute of King Edward III in the year 1351, and it was very simple. Treason consists of compassing the death of the king. That means imagining, scheming to bring about the death of the king. Now, 10 years before Emmet's trial, there was a treason trial in England of a radical group called the London Corresponding Society. And there was no doubt they were a radical group. They wanted to overthrow the government. They wanted annual elections. They wanted all that good stuff, so to speak. And they were charged with treason. They were defended by the great advocate Thomas Erskine and prosecuted indeed by Lord Eldon, one of the great lawyers of the time. And there Erskine submitted that it was for the jury to decide whether or not they actually intended to kill the king. Eldon said that an intention could be inferred from an intention to depose him. Erskine didn't dispute that, but he said the jury had to find that there was a positive intention. That was the law in England. And a very interesting thing was that one of the prosecuting counsel, a man called Mitford, who was an ancestor of Nancy Mitford, the writer, he had been Solicitor General and one of the prosecutors in the English case. He was the Lord Chancellor of Ireland, so he knew about the difficulty. The English conspirators, Thomas Hardy and others, they were acquitted. Now compare that to the Irish case. The judge simply told the jury, without objection from Leonard McNally, that if they believed that Emmet had been involved in the rebellion, that was enough to convict him of treason. No issue was taken of that, though that certainly wasn't the law that had been applied in England. Immediately after that case, the case about Thomas Hardy, William Pitt's government brought in an act to amend the law of treason. They said, if you conspire with the king's enemies, as Emmet had conspired with the French, that was enough to convict you of treason. But that law didn't apply in Ireland. Leonard McNally never took that point. In other words, having been amply bribed by the government, he failed to take points that would, I think, have occurred to any competent lawyer defending Emmet.
And finally then, did it make any difference, all of this manoeuvring by the British?
It's very hard to say. That's like supposing you had a football match in which the referee were bribed and he had disallowed a score. Well, does that mean that the other side, but for that, would have won? You can't say. But no attempt was made to defend Emmet by himself or by his lawyers. And there were certainly points that were well worth arguing.
Okay, Justice Adrian Hardiman, thank you so much for joining us today.